I'd like to call the meeting to order. Thank you all for coming to this special meeting of the Task Force's Compliance Amendments Committee and the Ethics Commission. Before we go around and introduce ourselves, I would like to first thank the Task Force's Compliance and Amendments Committee for the very helpful information that you provided to us in writing and for meeting with us here today. I look forward to a productive conversation. We certainly on the Commission are trying to do our best to figure out a way to faithfully implement the ordinance and really welcome your help and advice in that regard. So thank you very much.
Mr. Herr, if I could just add a comment on that. This has been a long process, probably longer than any of us would have liked, and we on the task force do appreciate the patience that you have shown us in waiting for us to weigh in on this very important process. So thank you very much.
Mr. Nee, with that, would you like to introduce yourself and maybe say a little bit about yourself? We can go around quickly since we don't normally meet together.
I am Richard Nee, and I'm a member of the Sunshine Ordinance Task Force.
Can you hear me? I'm Hope Johnson. I'm the chair of the task force, although this is chaired by the Compliance and Amendments chair.
My name is Bruce Wolf. I'm the vice chair of the Sunshine Ordinance Task Force.
My name is Allison Washburn, and I'm currently the chair of the Compliance and Amendments Committee. And I would like to express my appreciation for agreeing to meet with us, and after what's been several years of back and forth about some complex issues.
I'm Paul Rennie of the Ethics Commission.
I'm Beverly Hayon. I'm glad to have you here.
Ben Herr, I chair the Ethics Commission.
Jamie Studley, Vice Chair of the Ethics Commission.
Dorothy Liu, member of the Ethics Commission.
So I thought we could start this meeting with the very productive and I think pressing concerns that were raised in the task force's April 3rd memo, and in particular the concern that the task force raised about the Commission handling non-willful violations of the ordinance.
Point of order, general public comment. It's not on the agenda.
Sir, my understanding is that we would take public comment at the end. Ms. Johnson?
I don't know if Chair Washburn wants to discuss this or not, but before we begin, I wanted to address our legal assistants, our legal counsel here today. Our deputy city attorney, did you want to?
No, go ahead.
Our deputy city attorney, the hours for the Sunshine Ordinance Task Force have been pretty severely limited. And so in light of that, he was unable to assist us in this outside of, there were already over our allotted hours for the regular task force work. And the sitting attorney, there's a seat on the Sunshine Ordinance Task Force that requires you be an attorney. He is not able to participate. So we asked a member of the public to help us pro bono, and that's Alan Grossman, who is here, and your staff is here. So we may sometimes refer to him, and we relied in part on his legal advice for some of our work.
And I would welcome comments from Mr. Grossman and whenever you deem that it's appropriate.
Thank you. I just wanted to make sure that people knew who we may be referring to.
Great. I see him there in the front row, so glad to see that he's here. Ms. Washburn, perhaps if depending on how you would like to proceed, if you would like to have someone either summarize the memo. I mean, I think we've all read it and understand its contents, but just for the public, some brief summary might be helpful.
I think the person ideally suited to provide the summary would be the author of the memo, Mr. Grossman, if he would be so kind to speak to the principal points in the memo.
Mr. Grossman.
Unfortunately, I think for both of us or all of us, I'm trying out some new hearing aids, and they're not as advertised, let us say. I think the first point, from my point of view, is the radical change that was made from the June of 2010 policy decisions to the draft that was presented to the task force last November. The June 14, 2010 minutes, I think, very adequately describe the long discussion on the policy issues that were faced by the Commission at that time, and the level of input that was given by members of the public and the task force members, and the work that went in before it, including my own meetings with Susan Harriman on these very issues. So the change of course, which was dramatic and shocking, without having the same policy body that made those decisions here in a public meeting, the reasons why those policy decisions were being reversed by staff, I think was the biggest problem, and coming into it, because it was such a shock or surprise to those of us who had spent all this time for the last few years trying to develop what would be a suitable set of rules that would apply to the Sunshine cases that reached the Ethics Commission. So, as mentioned in the memo, it's the task force position that staff is not authorized and empowered to reverse those decisions. Only the Ethics Commission can do that. It's the policy body that made those decisions, and staff is simply staff. It has no innate or other authority, whether it could even be given such authority, to take the steps that it took in the proposed regulations that were submitted in November of last year. It's pretty clear under the Brown Act that they couldn't do it, but I think it's also evident that it would have to be the case. It could not be otherwise. So unless you have some disagreement with that position, that pretty much says what we have to say on it.
So Mr. Grossman, I appreciate your comments. As far as whether the Commission has the authority to implement the regulations, we understand as the Commission that we are the ones that make the decisions. Staff provides recommendations. I think staff has done its best to serve that role in the best they can, and I think they have given some considered analysis to it. And so I'm really not. I don't think it would be productive for us to sort of argue about or discuss staff and the interactions between staff and the Commission. I think it would be more productive to talk substantively about your concerns, one which I share, which is that I do think that the Commission needs to have a role in adjudicating and enforcing non-willful violations. And I would welcome the thoughts of my colleagues on this issue, but I think you raised good points with respect to that. I'm also cognizant that the task force does not want, does not think that the Commission should be re-adjudicating matters that you have decided, and I think I see the merit in that as well. I think one of my concerns is, on the other hand, I don't think the task force wants us to simply be a body that doesn't at all look at what was passed on to us. So what I think might be helpful is a process that would allow some sort of expedited procedure for non-willful violations where we would take what the task force found as a finding and put the burden on the other side, since the task force had made a determination that a violation had occurred, for the other side, the respondent, to show cause why that shouldn't, the task force's order shouldn't be enforced. I think that's consistent with 67.35D and our responsibility on the commission to enforce the ordinance if there are referrals or that are made after a 40-day waiting period. Mr. Wolf.
So I'm a little concerned about that because it is the charge of the task force to be making the determinations. And the enforcement purely is to come from the Ethics Commission. And that enforcement should be just as it is, enforcement. If there's a violation that's brought to you, let's say take it out of the Sunshine Ordinance. Let's just take it from any other part of the work that you do. You first have a determination that comes forward that there's a violation of something, and then there's a recommendation for certain enforcement. Either it's a penalty or a fine or something like that. That would be what you would be concerned about. You wouldn't necessarily be re-adjudicating it on the enforcement end. You can hear what the issues are prior to that, but once you've determined that it is in fact a violation, you then approve the enforcement. Here, we're doing that work for you. We're doing all the determination for you, and the ordinance is specific that the Ethics Commission would provide the enforcement in the willful failure matters. So I think at that point, there's no need to rehear or the entire merits of the case all over again, because then it just defeats the whole purpose of the process. And I think we should move ahead with the knowledge and the way it's written in the law that the task force deals with the adjudication portion, making the order of determination, and then if it feels the need to send it off to an enforcement agency that would then take action on that order, much in the way a court would issue an order and then it would have to be enforced by whichever enforcement agency or body would do that. So I'd like to see if we could proceed along those lines, because I think that's where the crux of the issue is here that we've had ongoing issues with.
Ms. Washburn.
Certainly, Bruce, I agree that with the problem that you brought up, but I think we need to backtrack a little bit. And I was listening very carefully to Chair Hur's summary of what he thought he was hearing in our most recent memo of April 3rd, and was hearing such things as you believe that the Ethics Commission does have a role in certain non-willful violations, perhaps. And that is different from what was proposed in the November regulations. So that's meeting our views on this a bit more closely. And secondly, that you also could see a role for the Ethics Commission under 6735D for, in fact, enforcing our orders of determination. And that's probably the 6735D. That's, that is, for me, the crux of a lot of this is that gives you the authority to help us see that members of the public receive documents that are for the members of the public, and public meeting laws are enforced and so forth. So, I really want to, if we could, focus on that issue first of all.
I think that's a great idea.
Enforcement. That's so much else hinges on that, us deciding that issue.
Ms. Johnson.
Just to go back a little bit farther, one of the things we're not addressing, which we don't know what your stance is on this particular issue, is that the memo that it is a recommendation from the staff discusses this idea of elected officials, department heads, and managerial employees. So when you say that you would be willing to, you're open or you want to enforce the non-willful violations, that's going to be for all of those, because one of our main concerns is that if you limit it, as you did in the Jewel Gomez case, to only elected officials and department heads, it eliminates the enforcement for a huge number of city departments and employees. It's an enormous number of people. So I think we need to hear from the ethics commissioners about that. I went back and reviewed the minutes and some portions of the Jewel Gomez case. And toward the end of that, there is a discussion where your executive director states that 6734, what was in question in that case, where you felt that you were unable to actually take an action against that particular individual, was a policy decision, and that the commissioners could have the staff research that. And I don't know if that was something that you had them do, and that's how we ended up with this new sort of stance in the November issue, or if, I'm not exactly sure from reviewing that where your stand was on it. I know that at the time it was decided that you couldn't take action, but if that's a policy issue, I'm not sure why that was the only choice at that time. So when you say that, if you could clarify.
Sure, and also a good point. And so Ms. Washburn raised the issue of focusing on how and if the commission is open to this handling non-willful violations, which I personally am in favor of. Ms. Johnson raised the issue of willful violations that are beyond department heads and elected officials. So to answer, in my view, the second question first, I am in favor of the commission handling willful violations of non-department heads and non-elected officials because I think based on the ordinance, based on the principles that are therein and the language, I think that is something we could handle. As far as the mechanics of how that would work, I think we'd have to, of course, work that out. But I'm sympathetic to that view as well, and I would welcome the thoughts of my fellow commissioners on either of those two issues.
So I agree. I am sympathetic to the concept of dealing with official misconduct by those other than in the department head, managerial, elected official, managerial city employee category. The constraint that I had with the Jewel Gomez case that was raised here is under 6734. I'm not sure it was so much a policy discussion of it as we felt constrained by the language of the ordinance itself, 6734. And I think that's where we started thinking of, well, maybe another way to handle it is to take a look at the definition of managerial city employee and maybe redefining it. Am I remembering correctly? That was my recollection. It wasn't that we just had a policy willy-nilly and thought these are the only categories we can handle. It was that the actual language of the ordinance says this is what we're going to handle, the willful failure of an elected official, a department head, or other managerial city employee. So at the time, we felt constrained by the definition given in the ordinance. And so I think that's where we thought, well, maybe there is some room, if we were open to it, is to look at redefining managerial city employee or some other way. Because while I'm sympathetic to handling other types of official misconduct that's not perhaps enumerated in the ordinance, I also would like to, if we're going to go there, figure out what our parameters and our boundaries would be if we're going beyond what the ordinance gives us authority to do. So that's my recollection of how we came to that decision. It wasn't necessarily a policy that the five of us just came up with or that the executive director just came up with. We were looking at the language of the ordinance itself.
And I will say that in my humble opinion, the ordinance does have some ambiguities, and I think certainly this is an evolving process for us and the staff. I mean, I know the staff has worked extremely hard to try to figure out how we can best implement the policies while being consistent and faithful to the language. So If our views are changing and evolving, I think that's only natural in light of the complexity with which we're dealing here. Mr. Rennie.
Well, as the newest commissioner and one who does not have the background of the 2-3 years that the commission has been working on this problem, I decided to spend a lot of time going back to those earlier discussions, looking at the Sunshine Ordinance as somebody who had not spent any time looking at it and spent a lot of time looking at it. And I have concluded that the position that was expressed by you, Mr. Grossman, in your April 4th letter is the position that I would come to reading the statute or the ordinance, that 6734, which is captioned willful failure shall be official misconduct, I view that that was sort of signaling that for an elected official, there can be no question about whether or not it constitutes official misconduct for purposes of the charter provision that talks about what are the implications. And that 6735 is the paragraph that deals with enforcement. And under that, as I read Section A, I think what the drafters were concerned about is that if you wanted to go in and get some sort of preventive relief or relief at the front end because they had failed to notice a meeting properly, and you wanted to stop the meeting, or you wanted to, or if you wanted to quickly deal with the question of trying to get the documents, you had to go to court to do that. The court could do that at the front end. But that if after the administrative procedures set under 6721 had been exhausted, although the question is whether they even have to exhaust them, then the complainant would have a right to go to court or to the Ethics Commission. And I see nothing in that D section that limits the ability of a complainant to come to the Ethics Commission only, or for the Ethics Commission to only consider willful misconduct. Now, the fact that I say we have the jurisdiction, I think, under the statute, and I respectfully, with all due respect to the staff, who I agree with Mr. Herr, does a wonderful job and as overworked as it is. But I can't agree with their conclusion as set out in the November proposed regulations that are now before you. That I don't think we are that limited in our jurisdiction. Now, whether we choose to exercise the jurisdiction in every case is a different question. And so that as a first question, if I were asked to vote, I would say, I think we have jurisdiction to deal with any claimed violation of the Sunshine Ordinance, whether willful or whatever. Whether we choose to do it may be a different question, or if we do choose to do it, whether for what might be more minor violations, we might want to have some summary type process so we can deal with it quickly. But that's where I'm coming from, and I will address some of the other issues that have been raised when we get to it.
Can I respond briefly to this? I certainly appreciate your comments about the legal analysis that's in the memorandum. But, you know, there's a history here. It just didn't start in November. It goes back many years, and I am sure with 3 new members on the Ethics Commission, there may be a lack of sensitivity simply because you were not exposed to this history, which goes back, I believe, to 2004, when Mr. Warfield's complaint went through the process at the task force and ended up being referred to the Ethics Commission for enforcement and was dismissed after a lengthy delay. And since Mr. Warfield's case, there are almost 40 records cases that have been referred to the commission by the task force. This was made the subject of a civil grand jury report. I don't know if you're familiar with it, but
I've read it.
But over the course of that period, what those of us who've spent a lot of time looking at it, each of these dismissals was based on a set of regulations that did not apply to Sunshine cases. The regulations that were followed by the staff were limited by what the charter said they were to apply to, and the commission had an obligation, if it was going to hear Sunshine cases, to look at them differently and have some process that was not the same. And the reasons are evident. Sunshine cases are totally open. There's no secrecy connected with them, and so they need that, first of all. Second of all, Sunshine cases are pretty complicated because of the statute. I had a case that was filed in 2007. It was referred to the Ethics Commission in 2008, and I wrote Mr. St. Croix, and I said, you're using the wrong regulations. This is not official misconduct. It's not a willful violation. It's an enforcement case. Ultimately, the case was dismissed by the commission under the regulations. Now, those regulations are very different in one respect. The staff has the right to review the complaint that is filed with it. The executive director analyzes the information that has been gleaned by the members of his staff, and then he writes a report to the commission, which contains a recommendation of either probable cause or no probable cause. If two or more commissioners do not ask for a hearing on that case within 5 days from the time they receive the report, it automatically is not heard by the commission. It's a default type of arrangement. So without a vote of the commission, without a hearing, the case gets dismissed under those regulations.
Mr. Grossman, let me stop you right there.
I'm going to say, Mr. Grossman, you're jumping ahead of where the discussion is. At the moment, all I'm focusing on is whether or not we have the power to deal with them.
Thank you.
We may well get to, and I'm sure we will, what might be suggested as a way to deal with these things in the past. Because, okay, so that I was essentially agreeing with you on the jurisdictional issues.
But this is not a jurisdictional issue, sir. This is a different issue.
Mr. Grossman, please don't interrupt, Mr. Rennie.
And I'm saying that we'll get to, if the decision is made that the Ethics Commission should deal with any claim filed by a complainant about a violation of the Sunshine Ordinance, we'll deal with the question whether or not there should be a different or special set of procedures. That's all at the moment. But I thought the issue that we were dealing with, and interesting enough when you say there's a history, and I saw the history, I don't know whose memo it was to the June proposed regulations, June 2010 proposed regulations took the position that we didn't have jurisdiction to deal with non-willful violations.
Actually, I
Ms. Johnson?
was going to get to that, but
Mr. Grossman, please.
but I
one
don't
moment.
need to do it now.
Yeah, thank you.
I just to not get too far past the previous point, one of the reasons I mentioned the Joel Gomez case is that Chair Herr's question about policy was that the staff had read 6734 in one direction, so that it said the second sentence, which says that willful violations by elected officials and department heads shall be handled by the Ethics Commission, limited the Ethics Commission to those two only. And Chair Herr said, well, perhaps that means that those are definitively heard by the Ethics Commission, but doesn't limit what the Ethics Commission can hear. And I didn't see that addressed in the staff's memo in November. They only went the direction that you were limited rather than saying that those two will be heard by you for certain. So I would also like to hear the commissioner's views as we go along on having that 6734 read in a more broad light, which is how the Sunshine Ordinance directs you to read it in more of a broad sense.
So I would like to address that briefly, and then to Mr. Wolf. I think, if I'm remembering my understanding correctly, that 6735 provides us with enforcement power over, the way I read it, willful or non-willful. Okay. So I don't think we need to necessarily get to 6734 to deal with the situation you described.
But that's for all of the employees, not just elected officials and department heads?
Right. So I think under 6735, we
Okay.
could conceivably subsume those under there.
Okay.
Mr. Wolf.
Actually, I would direct you to 6730C. 6730C actually deals with this in a much better way. Actually, 6735 is really dealing more with an individual not wanting to come to the task force if they want to go about it in their own way. It talks about a person, which is a general member of the public or what have you, but not specifically the task force. Under 6730C, in the middle, it says the task force shall make referrals to a municipal office with enforcement power under this ordinance or under the California Public Records Act and the Brown Act whenever it concludes any person has violated any provisions of this ordinance or the acts. And I think that is when we're talking about non-willful issues, that is where we're directing our vehicle for finding enforcement, and we're choosing your commission, to be that enforcement body. To do that. We can choose any number of other ones, but we don't feel at this time that they really know how to do enforcement on these particular items. We feel that with some of the other issues that you deal with as the Ethics Commission, it's a little more geared towards dealing with violations within the same respect as far as transparency is concerned. So this is where the thrust of the task force's non-willful comes from.
Thank you, Mr. Wolf. Mr. Rennie, did you?
I was going to say that I agree with you about that that the task force can make a determination, and they have one of two choices. They have one of two choices as I read this. You either can go to court or you can come to the Ethics Committee. And I heard your earlier statement about that the only role that the Ethics Commission would have is they would have to accept your finding as a matter of law and then just impose the penalty. Well, no court would do that. No court would say, if you went to the court to say, enforce this determination that there's been a violation, the judge might give some presumption to the agency, but he or she would make an independent judgment whether or not whether your determination was correct. And so that although I strongly favor coming up with some mechanism that would allow the determination to come before the Ethics Commission and possibly in some kind of a much more streamlined procedure so that it can be dealt with, but that I would never say that the Commission cannot make its independent judgment as to whether that determination is correct.
Mr. Ernie, let me stop you there. I think that is an important issue that I think it would be productive for us to discuss what enforcement looks like, but I would like to stay on the issue of whether the Commission should handle non-willful violations and willful violations of non-department heads and non-elected officials. That I think is, what I viewed as probably the most important issue, and I would like to hear if we have consensus on the Commission about that, or whether we should have further discussion about our jurisdiction in that regard.
This is just a matter of information. I would like examples of non-willful violations. That's not clear to me. I mean, I think that's one issue, the willful and non-willful. And then the other issue is who are the individuals that we have jurisdiction over. I mean, that's obviously very important, but to me, I have a lot of trouble with the non-willful, because that seems to be such a large area and one in which I'm sure a lot of violations occur that are non-willful, much more than the willful. So what are examples of that? And then the other issue for me would be, I'm sure that the non-willful violations at lower levels of managers is where that occurs to a much larger extent, either managers or employees of departments who aren't really familiar with what these violations are.
Ms. Johnson, if you want to provide an example.
I can give you just a quick recent example of one that we just found at our last meeting that involves an elected official who redacted some information about from some records and cited the California Constitution and the right to privacy as the reason for redacting that information. And that is not an exemption under the California Public Records Act that applied in that instance. So they were not redacting them purposefully, knowingly. They thought that they were following a particular exemption that didn't apply. So that's an example of something that's not necessarily willful, where they were redacting them knowing that they should not be redacting that kind of information. So that's one example.
And Ms. Johnson, if I have it right, in an instance where there's a non-willful violation and it's remedied, when it comes before you and the board and the task force determines there's a violation, it's remedied, typically those are not the sorts of referrals that you make to the Ethics Commission. Do I have that about right?
Correct. We try to monitor. We issue an order, for example, in that instance, we'll issue an order that says you have 5 days to turn over the information that was improperly redacted or redacted under an improper exemption. And then we have our Compliance and Amendments, this committee, monitor whether it was complied with or not. If they do not comply, it comes back to the task force, and then it may end up being referred to ethics. But if there was compliance, then we resolve it there.
So in other words, I don't think as the Commission we would necessarily expect to handle a lot of non-willful violations where if compliance eventually occurs and the task force is able to enforce the ordinance.
Right. And there are times when the sorry, I just saw a picture of myself on this. There are times when the willful violation will come to you when the respondent is refusing to comply or disagreeing. They won't turn over the records, disagreeing with that, whatever it might be. They may disagree that the certain things don't apply, that the exemption should apply and they refuse to turn it over, that's something that might come before the Ethics Commission that's non-willful.
So what's the volume that we're talking about in terms of, say, in the past year or two, if there were non-willful violations that you would have wanted to refer to the Ethics Commission?
I would just say that we have made referrals to other agencies like the district attorney or the state attorney general, and there are provisions to go that route first. But we have, there are a number that we would refer to the Ethics Commission if they were to be enforced.
Like more than 10 or more than 50, or what sort of numbers?
No, I don't think so.
Each year it's a little bit different. We had a really large volume of cases this year. It was a little bit unusual. But I can't remember off the top of my head. I'm gonna look out in the audience for a minute, someone who's been researching all of these cases. Mr. Minette Shaw, do you know how many cases have we referred this year? I'm asking, do you know? Or I think Patrick knows.
Are you asking me if
No,
I
I'm
know?
asking Patrick.
Oh, I know.
You do know?
Yeah, well, I have it right here.
Okay, you do have it. I only know that he was doing research on that recently.
Between 2005 and November of 2011, there were 35 cases. It's approximately 5 a year.
Okay, thank you.
And then the non-willful ones, what am I trying to say? Sometimes the willful ones are because the respondents won't appear. They won't appear at our hearings. And we need somebody to back us up that they need to appear and respond. And this is not just a local law, this is a state law. And the local law requires them to appear. But some of the laws that we're involving ourselves in are also state laws. So those you'll sometimes receive those kinds of referrals.
We won't necessarily claim them as being willful, even though people are they're not showing up willfully, more or less. But it's really important to try and, we don't have the authority, we don't have the, to force them to come. And that's why everywhere in the ordinance it talks about finding another agency or referring to another agency for enforcement. So here, if they were to come before you, not necessarily for a penalty or anything, but necessarily for you to order them as the enforcement agency to appear, that becomes a matter of record. And we think that that's important that they be put through those strokes because we take what we do very seriously, as you do, and we feel that the public's right to have their due process to get the records they want or to have their item be heard and have the respondents be present be important. It also causes extreme backlog for us and our agenda to be able to move forward when folks don't come, and then we have to continue and continue and continue. It gets a little tenuous for everyone. So,
Or they sometimes respondents will sometimes send a person to appear who doesn't have real knowledge and can answer no questions. So that is difficult for us to hear it. And that's part of the reason why, back to the jurisdiction, that's part of the reason why we're hoping that you'll take very seriously our consideration about it not just being elected officials and department heads, because with great frequency, the people who are in control of records don't fall under those categories. So if you go to the planning department and you walk in, they have a huge number of documents. And just to give you an idea, it's not just that they're violating necessarily the written black letter law, but sometimes their intent is to delay the documents until they're not useful to the person anymore. And this happens a lot with journalists, where they want to write something timely. And so that, taking into account those kinds of things, when they send somebody, when we only meet every 30 days, that doesn't have any knowledge, that makes it difficult. It's not always a department head that does that.
Mr. Nee?
Mr. Johnson, can I round out Mr. Grossman's answer, just
If that
very
would be
briefly.
useful to Commissioner Liu.
Very briefly, could I flesh out Mr. Grossman's?
Briefly, please, Mr. Shaw. Thank you.
So of the 35 referrals over the past 5 years, I think part of the concern about whether it's willful versus non-willful is that one or two of those 35 cases may have been dismissed by the ethics staff finding that the complainant, at the time they filed their complaint, had not alleged whether it was willful or not willful. But when the task force heard the case and determined that it had been willful and then referred it to ethics, it may have been dismissed simply because the complainant hadn't alleged at the outset that it was willful.
Mr. Nee.
Partly because of some omissions in the ordinance, and partly because of some differences in interpretation of the ordinance between the task force and commission staff. There have been some questions as to who is or isn't required to appear as a respondent in a complaint before the task force. One of the areas, for instance, is whether a respondent in a complaint dealing with public meetings, public meeting violation has to appear. It doesn't say that in the ordinance. The task force has determined that this is a question of the spirit rather than the letter of the law. But staff, ethics commission staff, says, well, doesn't say so in the ordinance. And so we're not going to find that that section of the ordinance, particularly 67.21E, was violated. So there are some differences of opinion there. I could go on, but in the interest of brevity, I'll let it stop there. But be aware that those differences do exist.
Thank you. I just want to make sure that the ethics commissioners have had if anybody else would like to speak on the issue of whether the commission has jurisdiction under the ordinance of non-willful and willful violations not involving department heads and electeds. Welcome comments. Commissioner Studley.
Mine is a question. I would be interested in, you're just saying a little bit more about how you think you would reach it. You talked about reading 6735, both you and the other proponents. Because we were struggling with the drafting of 34, in the usual interpretive standard is differences make a difference, and there's a difference. So we were trying to understand what it means. If you could just explain a little bit more about how you would use 35 to find that jurisdiction.
I would, if Mr. Roney doesn't mind taking that question, I think he has.
Well, as I read the ordinance as a whole, obviously it's got to have some enforcement procedures. Now, there are some administrative procedures, and in 67.21, one of these provisions is to go to a court to get an enforcement. But when you get to the section that's called policy implementation, and then specifically to 67.34, when I read that, the first sentence, I think, is the key sentence. And that is, it's focusing on whether or not a violation of the Sunshine Ordinance, a willful violation of the Sunshine Ordinance, would be deemed to be official misconduct. That was the concern, because the official misconduct, when you go to the charter for elected officials and that, is a very important phrase. And without that language, one could say an elected official could violate the Sunshine Ordinance, and it might be willful, but there'd be an argument on his or her part, it doesn't rise to the level of official misconduct. And that's what that paragraph was concerned about, was making clear, that's the way I would say 67.34 as I read it, and that the next sentence saying that it shall be handled by the Ethics Commission, that is the way the Charter provides how official misconduct by an elected official is to be handled, is that it goes to the Ethics Commission. Now, when you get to 6735, which is a much more broadly worded section, and you get to D, it says any person may institute proceedings for enforcement and penalties under this act. Well, enforcement has to contemplate that there's been some order somewhere, or at least he or she has made their application for public records and they've been rejected or they've been ignored, that regardless who that individual is, so long as it's a public record under the control of any public official, that it can go, either they can go to court or they can go to the Ethics Commission. And to say that, so I'm just saying as a broadly read section, it seems to me that section was intended to say, you as a complainant have choice, go to a court or go to the Ethics Commission. And the Ethics Commission can choose to do what it wishes to do at that point. But it's not without the power to do something. It may choose not to do something for resource reasons, for a lot of reasons. But I don't see how you can read 67.34 as a limitation going to 67.35.
If I could just jump in there briefly, and I know Mr. Wolf wants to raise something, but I think, Mr. Rennie, that was...
Speak into the mic for us who have hearing disabilities, please.
I will. I apologize if the public could not hear that.
Yeah, I apologize too.
What I said was I agree largely with what Mr. Rennie just eloquently described. I think 6734 is not necessarily exclusive. It does not preclude the Commission from handling broader matters, non-willful matters. Now, that's not to say that there's not, there is ambiguity here, because you certainly could potentially read D as limiting the Ethics Commission to willful misconduct because of the phrase "under this act," under D. And so, again, I think that has been part of the reason why this has been so complicated, is that there is language that is ambiguous and potentially problematic. I come out the way I do because I think it can be read both ways, and I think we would be implementing the purposes of the Act more consistently under one reading versus the other. Mr. Wolf.
Yeah, thank you. So a little, I agree in part. I think we need a little more clarification. For me, 6734 is siloed. It is specific to willful failure, and it's in the ordinance that the concept of willful failure comes up. It doesn't come up anywhere else. You don't see it necessarily in the Charter. You don't necessarily see it in many other codes that we have in the city. It is a term that is specific to the ordinance, but it states that willful failure for any, whether it's state law or the Sunshine Ordinance, shall be deemed. Now, that's an important set of three words. Shall be deemed as willful misconduct. That's not may. Official misconduct. That is, that's not may. It may be, it shall be, which is means that it is. The question is, which I agree with, is what rises to willful failure at that point. And our stance on this is that when we come to a point of finding willful failure, that we've taken great pains. We've gone through a complete process. It's not just done in one stroke. It's gone through a numerous amount of weeks of time to try and get a violation settled, or whatever the complaint is settled. And if it doesn't come to pass and a respondent doesn't comply, then they are actively refusing to do it, then it rises to a level of willful failure. And that's where the Ethics Commission comes into play, because willful failure shall be deemed official misconduct, and those issues under the Charter are handled by you. So that's where I see 6734 as being siloed for that particular purpose, for those particular kinds of violations. For 6735, that's exclusive of the Sunshine Task Force. That is for somebody individually on their own to be able to go out and actually try to get this resolved on their own. And that's why in every sentence it pretty much asserts that it's any person. And in D, the Act is the Sunshine Ordinance. It's not just 6735. It's the entire body of the ordinance itself. That's the Act. And it claims to be the same as like the Brown Act or the California Public Records Act. That's where the ordinance gets drawn its authority from and its jurisdiction. So I would see there in D that is exclusive of the ordinance of the Sunshine Task Force. If somebody did not want to go through that process and they wanted to go straight to a court, or they can come straight to you, but it's only after they have made contact with a city or state official that is supposed to take action on it. And if you read in the last part of that sentence. So they can't come to you until they've exercised or exhausted their complaint with a city or state official.
Ms. Washburn?
I'd also like to remind everyone about, and Mr. Rennie did this earlier, 6730C, which is where the Ethics Commission has the jurisdiction to hear cases that we send to you for enforcement. So I think the plain language of that is very clear, that it is in our purview to hold hearings about complaints that are brought to us, and we have a very lengthy process for doing this. And then when we decide the order has not been complied with after all this time and effort, then we refer these cases to you for enforcement. And I guess it doesn't seem to specify whether these are willful or non-willful, or city official, or head of a commission, the Arts Commission or Library Commission, or so forth.
So, Ms. Washburn, just following up on that, how do you read the 6730C, the provision you were just talking about, that's where we would get the task force making referrals to the Ethics Commission for non-willful violations, right, grounded in 6730C. How does that interplay with 6735D that Mr. Wolf was just talking about, in terms of a person being able to come before the Ethics Commission, but only if action is not taken by a city or state official? How do you all see that interplay?
Do you want me to answer?
Can I answer that?
I just want to clarify, and then I want to hear from Mr. Grossman. You have to look at the process under 6721E. That's where the hearing, we provide the method for hearings.
Sure.
And then once the hearing is done, if we wish to then refer it to another municipal body with enforcement power, that's what 67C is all about. 6735 is specifically for a person to circumvent all of that. Not go to the supervisor of records, not come to the Sunshine Ordinance Task Force, where they actively are trying to adjudicate this themselves on their own. So let's say they can't get a record. They then call up a city official. They call up the mayor's office. Mayor's office doesn't take any action on it for 40 days. Under the Sunshine Ordinance, they can go directly to you, or they can go to a court to get satisfaction.
So you're not seeing 6735D as the basis for the commission's authority to hear non-willful violations referred to by the task force?
It's not for the task force, no. It's for any person acting on their own volition, because if you look at A, B, and C, you have to start with A, because then it goes, seriatim. So you have to, when you start with A, it talks about any person who has a complaint. That's what we're talking about here. We're not talking about the task force. We're talking about any person, and there are many different ways that a person can exercise their rights under the Sunshine Ordinance to be able to get records. And so one way is through the process that's outlined in 6721. The other process is 6735.
Okay, I see.
Okay.
And then Mr. Grossman.
With all due respect, being the only lawyer on this kind of side of this group, I have to restate what I think I've stated a number of times. But I first want to mention what I was getting to when I couldn't quite finish about this letter.
Mr. Grossman, I'm sorry. We are what we are trying to do here is, and I appreciate the advice.
But it's relevant to what we're talking about. It involves 6734 and 6735D, and that's what you've been talking about.
Right, but what we were hoping for was an answer to Commissioner Liu's
I'm going to.
question. Okay,
if you could
start
that's
there,
what I'm going to
I'd
answer.
appreciate that. Thank you.
But you have to look at all of those sections in order to understand what 6735D is all about. There are three different ways a case can come to the Ethics Commission. Two are described in 6734, and one is described in 6735D. Of course, there is also the task force power under 6730C to send it to you for enforcement. 6734 talks about a willful failure to do a duty under any of the public records or public meetings laws. And that failure to willful failure is official misconduct, a finding of that. Official misconduct is defined in the charter as a certain level of behavior, and it also says that a finding of official misconduct anywhere else is official misconduct under the section that falls, that gives you jurisdiction over official misconduct. There are 15 other places in the charter where official misconduct can be found. This is one of them, okay? So that's a whole subset that is governed by a special set of rules, which you're going to deal with very soon. The second part of 6734 deals with a willful violation. That's different because it's focused on a violation of the ordinance. And that's a finding that can only be made by you under 6734. So those cases you get, okay? And that makes sense because that's what these proposed regulations deal with. Then there's the non-willful cases. And those are the ones that under 6730C come to you because a failure to comply with an order of the task force is a violation of the ordinance. And when there's such a simple violation, it goes to the Ethics Commission. And that violation has occurred because the task force has gone through its entire process, 2 full task force meetings, a Compliance and Amendments Committee meeting, and made a final determination that it needs to have this violation corrected and its order enforced. And that's what you're talking about when you talk about jurisdiction. And that jurisdiction is found in 6735E, which says if under 6121E, neither the Attorney General nor the District Attorney do anything for a certain period of time, the individual, the person, as Mr. Wolf said, can go to you or can go to the court for enforcement, because it allows for penalties. Because if you didn't have the penalty language, then the court in 6735A would simply do what it normally would do, which would enter an order, here are the records, you're entitled to the records, and your attorney's fee should be paid. So that's the structure. So this confusion between willful violation, willful failure, and a simple violation, that has all been known to your staff when they did these proposed regulations, way back when. And that's the distinction that we were making in the draft that was submitted last August.
Thank you, Mr. Grossman.
Thank you.
Commissioner Studley.
I'm sorry, go ahead.
I think I'm staying with the point. I feel like there are several balls in the air, and this is tricky territory. But there's something that has troubled me every single time we've walked through these, and that's the sentence within 6730C that we've been talking about. And I hate to obsess about a four-letter connective word, but I think there's the crux for me is that word with enforcement power. So let me put it this way. This is very clear that the task force shall make referrals to a municipal office with enforcement power. That takes it to the right place, to a place that has the authority to provide for enforcement. But it doesn't say, as Mr. Grossman said, it doesn't say for enforcement. It could have said, shall refer for enforcement, but that's not the language of the ordinance. It says, with enforcement, and then it leaves me dangling. I literally wish that if I had written this, I would have said, wait, what, to do what? So I'm left saying, it's very clear, you're right, shall make referrals to a municipal office with enforcement power. We're one of those. Whenever it concludes, blah, 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 and it tails off, leaving me with that question that's so important to us about where we pick up, where our responsibility picks up. And I'm sure that I'm left, that I now have to go to our authority, because this talks about the task force's authority. I have to find the second part of that path through these woods by saying, well, I got it, and the Ethics Commission is a place with that authority, but what is it that the Ethics Commission is supposed to do? And I'm left feeling that this doesn't tell me, so I have to look at what the Ethics Commission's authority is. And we do not have something that says you can just enforce other people's findings. So that takes me back to feeling that where you began, Commissioner Herr, is a logical place, that the effect of the task force finding is to shift the burden. It brings it to us with a finding, with the work and the foundation that's been set, but that we have to pick it up and do what's our job, which is to make a determination on our authority, and that it's perfectly fair for us to do that in relying on the task force to shift the burden, which for anybody who's had to go through this, or any lawyer, you know that that's a big deal, that the difference between you have to prove it or I have to prove it is quite meaningful and is respectful of the task force's effort up to that point. But but this sentence so clearly does not say for enforcement that I feel like I have to find the answer someplace else. Clearly, it's something that you've talked about because they all want to address it, but that's where I'm, an important pivot for me.
Ms. Johnson?
When we make the referrals, when I write the referrals, under 67.34C, we're referring, what you're talking about I mean, interpreting the
30C.
67.30C. Did I say 34? I'm
Yeah,
sorry.
that's like
30C.
understandable. I'm having.
When we refer that, the intent is that why would you refer it to something with enforcement power? To interpret it to mean anything other than to enforce it would be difficult, but we combine it with 15.102, which gives you the authority to carry out the purposes and provisions of ordinance regarding open meetings and public records. So that gives you the authority to, you're allowed as the Ethics Commission to make rules and regulations based on the open government laws. And because you don't hear a lot of them, one of the things that's different than in court is that all records are public. You don't have to prove they're public. The person who wants to withhold it has to demonstrate there's an existing exemption. That's why the burden shifts. You see what I'm saying? When you go to court and someone makes an accusation, that person has to prove the accusation. But when the complainant says, I want a public record or public information, in the California Public Records Act and in the Sunshine Ordinance, it requires the person who wants to withhold that information to provide a reason, an exemption.
Can I just say?
Yeah.
I think that the burden shifting I'm describing is at the next stage. I understand what you're saying,
so
but
that's
when
why
it comes to us, the burden would be, we assume that what you have said is right, and anybody who wants to challenge that has to make that case to us. Not about whether the document.
My point in saying that was just that, maybe I didn't make myself clear, but I was trying to address just what you're saying, and that is that our order is generally telling you this is public information and you need to provide it. And so enforcing it, the person would need to, again, tell you why they shouldn't have to turn it over. It would be this, it's almost the same idea, because when we send something for enforcement, we want them to turn over the document. We're not necessarily asking you every time to punish them in some way. Say it's for documents. We send an order saying, we find a respondent improperly withheld a document, and they won't release it. They won't disclose it. So we refer it to you. When it came to you, we might say we're referring this order for enforcement under 15.102 and under 67.30C, and what we want is the document. We want the complainant to receive the information that they want. So you're still going to be faced with this idea of whether there's an exemption or not. It's not like you're rehearing everything of whether it's public. It's a public record.
Ms. Washburn, did you want to?
So I'm just addressing that, how we combine those when I send them over.
Ms. Washburn, was there something you wanted to?
Yeah, I just wanted to pick up a thread. Commissioner Liu asked me how I saw 6730C and 6735D interacting. And I can imagine scenarios where the task force has made an order of determination. And that order of determination is for a person to, in most cases, to receive documents that are public. Mm-hmm. So I think you could read 6735D in such a way as that person has an order to be enforced and can bring that to the Ethics Commission. I mean, we're doing the referrals for that person. I don't know if this is the way. I'm not an attorney. I'm a college professor. But just reading the plain English of it, that makes sense to me.
You mean that the task force gives an order to the person, and the person is the one?
Well, the order is on behalf of the person. The complainant. The complainant who has requested this public document. Mm-hmm. And what we want the Ethics Commission to do is to help that person obtain that information. You know, that's our primary purpose. There are all kinds of ways city employees can violate the ordinance in terms of timing and not showing up at our meetings. But, you know, at the very bottom, the most basic thing here is that the public gets records and that the public has access in public meetings.
And I'd like to say that I'm very sensitive to that and fully understand that the goal here is to make sure that the ordinance is complied with. And I think now is a good time to move to the enforcement question, because I think it's important and one where we've already had a lot of discussion on.
Can I ask one question of Mr. Grossman? Mr. Grossman, you said, from your point of view, that when the task force issues an order when the complainants come to them, and the task force says the document's a public record, it should be produced, and it's not produced, that's a separate violation of the Sunshine Ordinance?
It's a violation.
It's a what?
A violation.
How is it a violation? No, the violation is the failure to turn over the document that he's been ordered to produce.
I'm willing to accept that. Either way, it's a violation. Either the initial failure that has been determined to be a failure by the task force, which then is a violation, which the custodian under 6721E can remedy by turning over the records. If the custodian does not do that, it becomes a violation that can then be moved by action of the task force to another body for enforcement.
Right.
It need not be the Ethics Commission.
But what is being moved to the other body is the underlying violation.
Well, it's probably the failure to comply with the order. But the point I was just alluding to is that the reference in 6735D to a person seeking a remedy before the Ethics Commission is for enforcement, because the task force does not always refer these violations to the Ethics Commission. It can refer them to other bodies as it has. Thank you.
So on this question of enforcement, I see two competing concerns, at least from my perspective, with this. The first is to expediently resolve the matter so that the person, so that the violation is remedied, or the purported violation is remedied. The second concern, as on the Ethics Commission, is that when we enforce the matter, I think we do have to have some review of what we were given. Like Mr. Rennie said, if a court were to receive a request to enforce, there would be some review of what we were asked to enforce. It wouldn't just be a ministerial matter of, okay, here it is, stamp it, on to the next one. So one thing I had in mind was to have a hearing that where the respondent or the complainant who had a order from the Sunshine Ordinance Task Force that was not being complied with would submit directly to the commission, no involvement of staff, and we would have a show cause hearing as expediently as we could at the next regularly scheduled meeting where the matter would be adjudicated. I certainly have concerns with staff has a lot to do, not enough time to do it, and I think this could be one way where we could enforce these matters in a timely, expedient manner, but also provide us with some review of what went on so that we could, in confidence and with the public's confidence, enforce the order. Commissioner Studley.
I think mine's just a quick question. You mentioned the complainant, and sometimes that's exactly who wants to do it and who should do it. I wonder there a little bit about the burden on somebody who, for those complainants for whom it's a burden to keep appearing or returning or who are not as skilled. Have you thought about the possibility that the Sunshine Ordinance Task Force could stand in the shoes of the complainant with the complainant's, I'm sorry, could stand in the shoes of the complainant with the complainant's permission to, at that show cause, if that were either the more expeditious or the more comfortable for the plaintiff. I haven't thought through all the pros and cons, but I don't want to make it harder on somebody who
complainant
has
shouldn't have to show
been
cause.
frustrated.
Right, I'm
The
sorry.
respondent has to show.
Yeah,
cause.
no, that's
Yes,
exactly
that's
right,
what
and I
yeah.
apologize. I
Yeah.
think I misspoke there. So in an instance where a referral is made to the commission, the respondent would be ordered to show cause as to why the order should not be enforced. The respondent, if the respondent didn't appear at that, I think we'd be left with no choice but to go with the record we have, and enforcement would be made. I think that it would be helpful for the complainant to appear at that proceeding, but certainly the burden is on the respondent to show cause as to why the order should not be enforced.
I would just say that the order of determination you receive, while it's maybe 1 or 2 pages with an encapsulation of what had happened, is not the complete record. So what you'll receive is the complete record will be the advisement of our legal counsel, will be all the evidence that has been presented either by the complainant and or the respondent. And then there could be some other documents that might be supporting that. So by the time we're through with our process and you receive it, you will have pretty much a very, very complete picture of what has happened. And then you'll have the opportunity to the minutes and or to hear the testimony by audio if you feel the need. So there's plenty of information that you'll have, and it should be fairly expedient at that point, because it leads all the way up to that point of the respondent having to prove their case, why they should or shouldn't have been in violation. So I think I don't think you should be concerned too much. I think it'd be organized pretty well, so that you'll have documents in time because they would have been sent to you well in advance, and we can appear to answer any questions. I think it would be a great idea that we would be there on hand to answer any questions that you might have, so that because we would be knowledgeable about it firsthand.
But you would have it designated like a single person.
Yeah, it could be somebody either from a member of the task force or what have you. Sure, we can do that.
If I could just point out quickly that this is the reason why the task force recommended a 2-prong approach to your regulations, the willful violations and the enforcement. So that is why you'll see when you look at our response to your proposed regulations, we divided them in 2. And I just thought this might be a good point for you to, think about that. That's why, because it involves these 2 sort of separate kind of lines.
Thank you for raising that, Ms. Johnson, because I tend to agree with you. I think the procedures outlined in the staff's memo for willful violations, I think those are good, and I think we should use those for willful violations. I think for these non-willful violations that we're talking about, this more expedient process, this show cause process, is something that makes more sense, and I think, to me, would better achieve the 2-pronged goals of making sure we get the ordinance enforced as quickly as we can while maintaining the requisite due process and giving the commission and the public confidence that we're following our mandate as well. I don't know if there are any other comments from the commissioners.
Can I give you another thought, because I agree with what you're suggesting, but rather than, and again thinking in terms of time, rather than holding off until the next regular commission meeting, how about the idea of, on a rotating basis, the chair appoint one of the commissioners to conduct the hearing, to give a recommendation at the next meeting, so that we could do it within a number of days after it came to us, rather than waiting a month or so.
Renee, would you please speak into the mic?
We need you to speak into the microphone.
I'm sorry.
Thank you.
I have a hearing loss.
I'm sorry. My suggestion was that maybe another way to speed it up is that to have this show cause hearing before a single commissioner within a very short period of time after the submission, and then he or she make a recommendation to the full commission at its next meeting as to what should be done, and then the commission can either proceed from there.
Commissioner Studley?
I'll just be completely candid about that suggestion. If you want to do that on a voluntary basis, that's fine. But I am not in a position to take that on a mandatory rotating basis in addition to the other work of the commission.
I think the chair can take care of that.
Thanks very much, Mr. Rennie. Other comments on this? I mean, I would like to hear from staff as well on this. It seems, given that all that you guys are doing, that this might be something that might work well and perhaps better in terms of your timing and the best utilization of the staff's resources.
The staff is anxious to move forward and get new regulations in place, and the idea proposed sounds workable to me, speaking for the staff. So I suggest that we move forward with this process and see how it works over time. And given everyone's interest in making it work, hopefully it will. If there are problems or unintended consequences, then we could revisit how we handle these processes.
And I would at least envision some role for staff, and Mr. St. Croix, I don't want to put you on the spot of adding additional things that the staff has to do, but certainly being the body that receives the records, so that just logistically receives the records, schedules the hearings, and so on. But the idea would be to not additionally burden staff with making recommendations or having to investigate the matters.
Can I make one suggestion?
Yes.
The regulations that came out in November of last year, the proposed, were in response to a draft submitted by the task force. That draft represented the collective view of this group on what should be in the regulations. And that's what triggered this very significant departure. But in that draft, there was, as Member Johnson, or Chair Johnson said, these two tracks of a non-willful and a willful violation. And although the issue of what the role of the commission would be on non-willful is a little different than what the task force perceived it should be, I think that on the willful aspect of it, it would be helpful if the staff looked at that so that when and if they go forward on that part of it, they will see what was of interest to the task force, and if they would comment on it rather than redoing it all over again, it would speed up the process. I personally have looked at the proposed regulations dealing with willful violations, and there are a number of problems with them, but I don't think this is the place to air those.
Mr. Grossman, I'm sorry, I missed what you're suggesting we do about that.
There was a draft that was that the commission staff prepared in following your June 2010 meeting.
Right.
That draft was not responded to by the task force until August of last year, August of 2011.
Right.
And rather than commenting on that draft, staff basically took over the responsibility of redoing another draft completely and eliminating all of the provisions that dealt with non-willful violations. So what I'm suggesting is that might be helpful if they're going to go back to the drawing board is to look at what was done by the task force last summer and recognize that this represents at least some of the views of the task force and try to incorporate them as best as possible. And on the willful side, that too represents what the task force thought would be a good way to handle it, rather than having a whole separate redo from the get-go.
I understand your point now. Ms. Johnson?
I would just like to, because we're talking about the Ethics Commission staff, and this has come up a number of times at the Board of Supervisors and with the clerk of the board, the Sunshine Ordinance Task Force is an 11-member body, and we deal with the public, all of the public, not just the San Francisco, but people approach us from all over, especially during election times, and we have one person that helps us. We have no budget. And so I would like to commend our staff person, who's actually a clerk staff person, who is here, Andrea Osbury, at this moment. But the burden that is placed on your staff is we do this repeatedly. So we don't have a staff.
Ms. Johnson,
And I'm just trying to, which is part of the reason why Mr. Grossman is helping us out. So it would be helpful for us to have some sort of feedback based on what we had provided in light of the idea that the commissioners have some agreement that they would like to encompass more than what the response was, the jurisdictional response was of the staff. So, and it's
I have full confidence that the Ethics Commission staff, hearing what this discussion is going to put forth regulations that are consistent with our discussion. But I certainly appreciate that we all want that.
Yeah, I've found this divide between staff and commissioners odd, because the process has been that we recognized, as you did, that our procedures were not a good fit for Sunshine issues, and we all recognized that we needed to make changes several years ago. I don't want to think how many years back, and have had this back and forth. We had a meeting several years ago on this subject. We developed a proposal. You reviewed it and made your changes. What came before us in November was meant to help the commissioners get to a point that we saw something that we could vote on and put in place, and we said we would like to meet with you about resolving that. So there's not the staff didn't create new rules that we are trying here to undo. The staff supported us by bringing something forward that seemed to, that based on their experience, was an effort to incorporate our concerns and yours. And we said, let's talk with you and see what we can do going forward that's as smart as we can make it. So I appreciate the spirit of looking at where we can go together and how we can get there as efficiently as possible. But I would like to put aside this sense that the staff is doing, or putting this in the affirmative. The staff is helping us, and by extension all of us, get to a place where we have rules that we think make sense and procedures that we don't keep butting heads or wasting people's time or starting from scratch in a way that's not efficient, and I think the fact that we found one pathway forward, I appreciate the chair's giving it this much thought, perhaps your dog does too, that I'd like to see where else we can find that kind of common ground to address some of these other issues. And I agree with the chair that we will take all of this into account in reworking whatever we have to and filling in the spaces in our shared statute.
And sort of following that, I would like to personally thank staff for the hard work on this. I mean, we've pulled you and pushed you in all sorts of directions over the last few years. You've done it one way. We asked you to try to do it another way, and now we're moving again. So I recognize that and I think our commission has been somewhat of a moving target because this is a difficult area. You spend a tremendous amount of time looking at these regulations and trying to craft something that makes sense and is consistent with the ordinance, and I really do appreciate the long hours and hard work on it. Are there other issues within the memo, within the Sunshine Ordinance's memo that we should address that are substantive? If not, perhaps we can move to public comment. Mr. Wolf?
I would just like to review where we are. We brought up certain points. We've either made agreements on some, or it's left in question for more information that needs to be gathered and determined. Like, for instance, your process for show cause, which I think is a good way of going about it. I'm just wondering, we had some issues around the willful failure and who is involved. We have some questions hanging about managerial employees. Is that correct?
So, perhaps it is, and I think
I just don't want us to leave here. This is not a common meeting that would normally happen, so it's important for us in the task force, and I'm sure for you, let's get some closure on these items, and then we can meet again if there are some other items that come up beyond that.
Mr. Wolf, I think it's a very good suggestion to make sure that we summarize and clarify where we think we're going. I will make an attempt to do that, and please jump in if I have misstated something or if I am off base. So the Ethics Commission will handle the alleged willful failure of an elected official, department head, or managerial city employee with respect to violations of the Sunshine Ordinance. We will also handle referrals from the Sunshine Ordinance Task Force of any violations of the ordinance, willful violations of non-department heads, managerial city employees, and elected officials, and non-willful violations as well. For non-willful violations, we will have an expedited show cause type hearing that we will have to, of course, work out the details of, but which will entail the respondent having to show cause why the Sunshine Ordinance's order should not be enforced. In addition, I think we will have to discuss with the city attorney's office and the commissioners specifically what sort of enforcement penalties or outcomes we'll have to that we can and should put in place. Obviously, if we enforce something, we'd like to be able to actually do something and make sure that the enforcement is carried through. So that's something that we'll have to also address. Is there anything I've missed?
Do you have one question?
Yes, Ms. Johnson.
In June of 2010, the commission voted on 3 procedures. When you do your regulations, when they do come before you at a hearing, will you go back and, my question is, how are you going to deal with the decisions that were already made? Will you go back and revisit them and revise them based on what we do here and vote on them again as a commission?
Well, I guess what I was envisioning was the staff would go back and put together revised regulations, or maybe it's more efficient to do a memo outlining what the policy points would be, and instituting the policies that we've talked about here. I guess I'm unclear as to what you mean by.
Well, they're similar. Well, they're a little. What we discussed today is pretty similar to what you discussed back in June and actually voted on. When the new recommendations, the November ones, came out, it very much departed from that discussion. So now we're kind of back on the other side, but the commission did take a vote. So like at the task force, there's been a couple of times where new information came, over the years, and we had to undo our vote before we could rehear something we voted on. So since reconsider. So I just wanted to make sure that these discussions would not get lost. Your vote as a body would not be lost as the new commissioners come in. I mean, you voted on 3 procedures that are kind of similar to what you have now, but then it was revisited by staff and changed after the Jewel Gomez case, because it removed some of your it limited some of your jurisdiction. So now you're going to go back and revisit it. And I'm just curious. I want to make sure, among other things, that the members of the public would be able to, hear your vote on something again and make comment on it again.
Commissioner Studley.
Well, I think the short answer is if we went back, changed something that we had done at that point, we would have to surface it in the usual way.
Okay.
But I don't mean this flippantly, but did you like what we did in June? I mean, do you think we did the right thing at that time, and is that something that you think we should be preserving? I cannot remember exactly what they were, but
it's in your
my question
packet.
is, were we on the
Your
right
minutes,
track?
the minutes are in the packet, and some of it, I was there and I commented on it, and some of what we've said, and there were a number of people there that are here tonight that this afternoon that commented on it too. And like I said, our concern about it was that yes, we did agree more with you, our findings at the time in June than the November jurisdiction, which was much more limiting.
Right.
So
our effort at the time in June was to do those things that looked like that we were all moving in the same direction, and to leave aside the ones that we didn't feel we had achieved resolution yet. So.
okay.
And my recollection is that the Sunshine Ordinance Task Force's memo came after this.
Yes.
And I think so. But I hear your concern.
Okay.
Jack, do we need to, Mr. St. Croix, do we need to do any vote here?
You can't. This is a discussion-only meeting.
Public comment beforehand?
You can't vote because it's a discussion.
It's a
No,
discussion.
the agenda is a discussion. There's no
Okay.
action plan, so.
Okay. Thank you.
Could you hear that, sir?
I did, thank you.
Okay.
But when the new regulations are drafted, at that point, we would carry out the usual, we'd have
Right.
another discussion and vote at that point.
Right.
And public notice and everything would be complied with it per usual, right?
That is my understanding.
Okay.
Mr. Nee?
Mr. Chairman, when public comment begins, or sometime during public comment, I will have a statement to read from Bob Planthold. I can do that from here or from the public podium, whichever you think is more appropriate.
I have no objection for Mr. Nee to stay where he is, unless Mr. Shen, is there any legal issue with that?
No.
No. Okay. Okay.
At the time public comment is called, and whenever, I don't need to kick it off, but sometime during public comment, I would like to read Mr. Planthold's statement.
Okay. Thank you.
So I just, did you get an answer to your question about whether you had covered all the points? You agreed Mr. Wolf made a good
Yes.
suggestion. I just wanted to close that loop so we didn't
Thank
have
you.
it
Satisfied?
circulating.
I'm satisfied with that.
Okay.
Okay. Okay, so public comment. Mr. Shaw.
Thank you, Commissioner Herr. I'm Patrick Manette Shaw. I'm here on my own time as a private citizen. For SF.gov TV viewers this afternoon who may not have seen the SOTF's April 3rd memo, I'd just like to read a quick portion of that. The SOTF's primary concern had been that the ethics staff's draft had so drastically restricted the Commission's enforcement jurisdiction as to render enforcement non-existent. Another part of SOTF's memo indicated that the staff's draft would also eliminate the Ethics Commission's jurisdiction over all city board and commissions and their staffs. So it's heartening to hear this discussion today, and that the Ethics Commission is now ostensibly going to direct the ethics staff to completely rewrite their guidelines for enforcement. Those guidelines for enforcement must be rewritten. Finally, I would like to remind both the Ethics Commission and the Sunshine Task Force members that the task force found Mr. St. Croix in willful violation on my Sunshine complaint 11013, and the city controller also in willful violation on both 113 and 11114. I have begged you over and over to expedite scheduling a public hearing on both of these willful failure complaints. Obviously, Mr. St. Croix is going to have a recusal problem. But I am asking you once again, when am I going to get some justice on these two cases? They involved Laguna Honda Hospital and the Patient Gift Fund. And there may or may not have been some involvement with the Laguna Honda Foundation. So we'll address whether other people need to recuse themselves as well when this hearing is scheduled. But you must expedite providing me with a public hearing on my two complaints.
Members of the Commission, members of the task force, Ray Hartz, Director, San Francisco Open Government. I want to just take a moment to go back to what I believe is the core of everything you're discussing here, and that is the oath that each and every one of you took and all members of boards and commissions take to support and defend the Constitution of the United States, the state of California, and subsequently all of the laws that flow therefrom. The First Amendment guarantees the right to freedom of speech, and I think the Sunshine Ordinance and the Brown Act both go to support and ensure that members of the public who wish to participate in public meetings are enabled to do so and to make comments, including those needing particular protection, which are dissenting comments. The right to petition government for redress of grievances in most cases is going to demand that unless you're making just wild accusations, you have access to public records so that you can prove and show that what you're saying has a basis in fact. And I think the California Public Records Act and the Sunshine Ordinance are both there to establish the right of a citizen to access the necessary public records so that they can put forward a cogent case to support what they're presenting. One question, and the task force members can say, yes, this is something is one of his bugaboos, is I asked them to consider their performance in the light of what have you done to support the right of a citizen to speak freely at public meetings, and what have you done to support the right of public citizens to access public records in their efforts to petition government for redress of grievances. And I think that's the very basic core of what they're there to do. And I believe that the discussions you've had today go to that same thing for the Ethics Commission. What have you done to support the rights of citizens to ensure that they have the ability to participate in government and make public comment? And what have you done to ensure that members of the public who need public records are given the appropriate access to support that effort? And if you can look back and say, well, the record isn't that good, that is one of the main underpinnings for everything you're doing right now. If a citizen can't come and speak openly and speak honestly and get the records they need to do so, then basically any body who denies them that right is violating their oath of office. And I think that is something that unfortunately many city bodies do not take seriously.
Let me speak next. You can start the clock if you like. I've asked you to pass those down if you could as part of my public testimony. Let me begin by saying that I came to the meetings in June of 2010 where these were last discussed. The fact that you're complimenting yourselves for almost a full 2 years of spinning your wheels does not impress me that much. I was the chair of the Sunshine Ordinance Task Force when it began in 2005, 2006. I'm a little bit shocked that I feel like I've thrown a snow white snowball off a snowy mountain to find that there's this amorphous mass of garbage that ended up at the bottom of the mountain, 17 years later. Let me just begin by talking about official misconduct. If you look at 6734, willful failure, the restriction there is with respect to a distinction that we used to make all the time between omission and commission. Willful failure of an elected official, department head, or other managerial city employee to discharge any duty is by its nature a sin of omission. They've got a duty, they're drawing a paycheck, they didn't do what they were supposed to do. With respect to official misconduct itself, you might look at your own ethics commission regulations, which define official misconduct in section 15.105 as official misconduct means any wrongful behavior by a public officer in relation to the duties of his or her office. And presumably, people can do all kinds of things without making an omission of a sunshine duty and be guilty of that section, and that section would trigger your enforcement. I want to take a few moments to talk about the burden that you've placed on the complainant, as if it's the duty of every private citizen to come in here and defend his duties from his rights from scratch all over again, as if every other citizen has not come forward already and should have established those precedents. You know, we have a situation now where Jewel Gomez has, I believe, wrongfully made a police complaint for purposes of political retaliation. Are we going to just go from scratch and make her guilty of official misconduct a second time so she can ignore it again? I hope that's not going to be the result of all of this effort. Thank you.
I realize that 3 of the commissioners are new and weren't around in June of 2010. I also realize it may be correct to say that none of you have ever attended a Sunshine Ordinance Task Force meeting at which the task force heard somewhere from between 5 and 8 complaints, primarily on public records matters and the extent to which they spent a lot of time and the follow-up meetings to make sure they had it right before it ended up with you. So my question really is, have you ever wondered how it is that in this 7-year period, somehow, through sheer coincidence or some other unknown intangible, every records case was dismissed, that none of them had merit? How is that possible? I'll give you an example of one of the reasons why a case was dismissed. It's in Mr. St. Croix's letter, November 5, 2008. When there is a conflict of opinion between the task force and the city attorney's office, the Ethics Commission, that's you, recognizes the city attorney as the lead attorney for the city and county of San Francisco. Having been elected by the people of San Francisco to that position, the city attorney is a higher authority than the task force, whose members are just appointed. Like you, you're just appointed. That was the basis on which a case was dismissed. And when I asked for a copy of that legal opinion from the city attorney, it did not exist. And when I filed my lawsuit and asked for the file to see what was in it, there was nothing. Zero. So my point is, there is a reason why all these cases were dismissed. I know what it is, and I think if you thought about it, you would eventually come to the same conclusion. Thank you.
Good afternoon, commissioners and members of the task force. My name is Paul Currier. I was a candidate for mayor on the November 2011 ballot, and it's nice to see you guys trying to work together. It would be nice if the city family, everybody could get along and actually do their job. My concern is, on November 11th, the central tabulation unit of the Department of Elections that was run by Dominion Systems completely threw the vote. Now, we know that in March of this year, 2012, that Dominion got busted in Palm Beach, Florida, and their systems that we use here in San Francisco to tabulate our votes assigned votes to the wrong candidates. And when you have a ranked choice voting system with 16 candidates on the ballot, like in our race for mayor, wow, if the system of central tabulation is assigning the wrong votes to the wrong candidates, we got a bad election. When you have 460,000 registered voters and 6 out of 10 don't vote, that's 6 out of 10 voting against the official family. And when only 84,000 vote for Ed Lee, who appoints the Ethics Commission, that's only 18% of the voters in San Francisco that voted for a mayor that authorized an election system where the central tabulation is fraudulent. Where do you go to make complaints for this type of thing? As a candidate, I was not allowed into the locked door to see the process. So I'd like to, I'm living in the housing authority. I'm not one of the wealthiest people in town. We have a problem at the housing authority where $30 to $40 million contracts are being awarded routinely, and no 72-hour notice is being given to anybody about what constitutes those contracts and who the bidders are. And it's in complete violation of the Sunshine Ordinance, and President or Chairman Amos Brown and the Housing Commission is complete violation of federal law, state law, and local law. And where do you go to make these complaints? I looked at some of this stuff, these issues today, jurisdiction, enforcement. As you go forward, the solution that I'd like to propose is give staff to the Sunshine Commission and set up a two-tier process where they could handle some enforcement with financial sanctions. And then if things required greater review, like removal from office, then that could go to the Ethics Commission. Thank you.
Good afternoon, Ethics Commission members and Task Force members. First, let me say, Thomas Piccarello, I want to thank you, both entities, for getting together finally and attempting to work out your differences. You need to focus in on what the goal that you're seeking today is, and that is getting citizens the right to public records they are entitled to, and citizens having the ability to participate in open meetings. I wasn't here for the entire discussion. There were a couple of points that were mentioned, though, I would like to address. First of all, I don't think anyone from the task force has ever suggested that you would not have the ability to hear issues trial de novo. The problem has been you have never had a trial de novo. I'm sure you've read your grand jury report, Sleeping Watchdogs, and I'm sure that that was one of the primary motivations of you finally having this joint meeting. So no one is suggesting that you don't hear all the issues first impression. What the public is asking the Ethics Commission to do is at least review the findings, the orders of determination by the task force, and determine if there's any merit. Secondly, I heard a comment about, well, there was a question regarding the volume of cases. Volume of cases should never be a criteria whether or not you accept orders of determination for your trial de novos. If you would begin to hear some of the cases, I can assure you there would be less volume of cases and orders of determination by the task force. Thank you very much.
Good afternoon. My name is Dr. Derek Kerr. This meeting was reassuring and a big relief. I don't know why it had to happen because of that document that deviated from where everyone was going. I recall the civil grand jury report that pointed out that the executive director had too much influence on the commissioners. I recall that 96% of the Sunshine complaints get dismissed. They probably never get to the commissioners. Similarly, whistleblower retaliation complaints. Not one has been sustained since this commission was founded. All of the investigations, the preparatory work is done by the staff. And looking at the staff's proposal that led to this meeting, you can see the legal technicalities, the restrictions, the narrowing down of the intent. I think that's where the problem is.
Good afternoon, commissioners and staff and members of the public. My name is Lynn Gavin. I'm a candidate for supervisor in District 7, 2012. I'm here as, this is all new to me. I have a case that was referred before you. I don't know if you'll hear it. I didn't know it would be referred, but I am glad that it was because that particular case, it took a lot of time, and the Sunshine Task Force worked very, very hard on it. One of the things that I'm concerned about is a lack of open government. I want to commend all of you for all of the hard work that you do. And one of the, some of the stories that I've heard, oh, if he goes to ethics, it'll go nowhere. I don't know that. But one of the things I will say is that I am very appreciative of the numerous hours that the Sunshine Task Force has spent, and it's teaching me. And as I learn, I brought Paul today, but we are beginning to work with other people to invite them to participate in open government. As a person of color, I'm very concerned about the lack of diversity at some of these meetings, because I'm not the only one who has a grievance, whereas I'm sure that our residents who are in Hunters Point or Bayview or the Mission District, they have grievances as well. So you have, as the task force, the Sunshine Task Force and the Ethics Commission, you have a lot of work to do. I do comprehend that everything's political, even though we like to say it's not. It really is. But, and some of these decisions that you arrive at may not be something that you would want to do because friends are involved, maybe distant relatives, but you are here for the people. You're here for me. And I hope when you're involved in your work, and it's very difficult, that that is not lost, that you are here for all of San Franciscans, and it is truly a very diverse city. But until my case, people thought they were disenfranchised, they were in despair, and I had to do something to help my community. And going forward with Sunshine was one of the remedies. So you are here on behalf of all San Franciscans. It's nearly 1 million of us, I think, now. So I hope that you just truly keep that in mind with your work and not lose sight of that. Thank you.
Peter Warfield, Executive Director of Library Users Association. I am somewhat encouraged by today's meeting, and I certainly appreciate the time and effort that all of you have put into this. I certainly hope that this will result in some action fairly soon. That will be a positive one. Mr. Grossman referred to a 2004 case. That was my case against the library. Even though the library didn't even bother to show up for what they called an enforcement hearing, which the Sunshine Ordinance Task Force held, and even though they specifically said that the specific 2 people that were requested from the library would not show up at that hearing because they were unavailable, that kind of flouting of the law, including the finding of a violation. Nonetheless, when this reached the Ethics Commission, and I think I have mentioned this case previously, some of you may not have heard it. In brief, there was no word of any kind from the Ethics Commission. I tried to contact someone from the Ethics Commission and say, look, despite all of the possibly confusing papers that you're getting from the Sunshine Task Force, including papers where a case that I had filed a year previous was slipped in with the record, so that it was quite confusing to try and sort out what does this have to do with the case. I said it was fairly simple and that I'd be very happy to cooperate in any way. It was a simple case of a request for information that the library refused to satisfy. I never heard anything from the Sunshine, from the Sunshine Task Force, but it was with the Ethics Commission. I never heard anything from the Ethics Commission ever again about that case. I didn't hear anything about what their process might be. I didn't hear anything about what their procedure, what the hearings might be, hearings or no hearings, how it worked, what the criteria might be. Absolutely nothing. And the way that I found out about the Ethics Commission's dismissal of this case was by chance when I visited a Sunshine Ordinance Task Force meeting and heard a passing reference to a letter that the Ethics Commission had sent to the Sunshine Task Force. I certainly hope that all that you consider from here forward will include considerations of how you provide justice to the public. Thank you.
Mr. Nee?
This is a statement from Bob Planthold, and as I read it, bear in mind, please, that it was delivered to me verbally by telephone before this meeting began, shortly before this meeting began. I, Bob Planthold, was on the Sunshine Ordinance Task Force for 7.5 years and was chair or vice chair of the Ethics Commission from 2002 to 2004. I am the only person ever to serve on both bodies. I filed various complaints with the Sunshine Ordinance Task Force. All were upheld by the task force, either unanimously or by all but one vote. The Sunshine Ordinance Task Force agreed with me, yet all my complaints were dismissed by the Ethics Commission. Ethics said the complaints would not stand up in court. The Sunshine Ordinance does not say complaints must be court sustainable, nor has Ethics instructed anyone that a complaint must stand up in court. Ethics is formulating a requirement that has no basis in law and is unknown to anyone. In regard to the 123-page memo from Ethics, this again shows an attempt to avoid dealing with complaints by focusing on whether a violation was willful. There is an easier way to address this. There is a requirement of commissioners, department heads, and program managers to take periodic training in Sunshine and Ethics. People sign that declaration under penalty of perjury. Thus, if an employee complained against has signed that document, it is possible that they have been negligent in their retraining and have committed perjury by signing it. If Ethics simply looked at whether the sworn statements are filed, that's an easier way to establish whether there was negligence and culpability on the part of the respondent. Ethics approach now is hyper-legalistic and will discourage complaints from being filed. Again, these observations are coming from the only person ever to serve on both the Sunshine Ordinance Task Force and the Ethics Commission.
I would like to, once again, as we close this meeting, thank the task force for your assistance, the commission for their work, the staff of both bodies, Mr. Grossman, and the public. I think we all have the goal of trying to faithfully enforce the ordinance, and we appreciate your help in helping us get there. So with that, the meeting is adjourned.
Thank you, Commissioner.